First to the story that we've been tracking the last couple of days, and we're getting more and more revelations in the Mumbai hit and run case where the accused is now in 6-day police custody. India Today has accessed Mihir Shah, the accused remand copy. The police in Mumbai say the victim dragged from the accident site to a landing point of Bandra Worli ceiling. Just think about it, over 2.5 kilometers the victim was dragged in the car. The police say Mihir Shah was behind the BMW wheel during the accident. Then the police say Mihir Shah and the driver switched seats after the accident. The police say the chain of events is based on CCTV footage. But crucially, the police have not filed murder charges, but they've filed culpable homicide not amounting to murder. So you've got a case where no murder charges have yet been filed, even though the evidence clearly points to the fact that Mihir was the one who mowed down the woman and she was dragged for 2.5 kilometers in the car. Our correspondent Devesh Singh is joining us live with the very latest on that. Devesh, why is the police reluctant to file under section 103, which is murder, under the new BNS law?
Well, Rajdeep, a big revelation has come to light in the remand copy. Remand copy describes the CCTV footage of the Worli Bandra ceiling landing point. It is seen that from the accident spot to the landing point, Mihir Shah was behind the wheel and the woman Kaveri Nakhwa was stuck between the wheel and the engine. At the landing point, Rajshri Bidawat, who was the driver of Mihir Shah, got off the vehicle. He inspected the vehicle while Kaveri Nakhwa was still stuck in the vehicle. He asked Mihir Shah to get off and switched seats with him. Now Rajshri Bidawat was on the wheel, and as he turned the vehicle towards ceiling, Kaveri Nakhwa got released of the vehicle. She was released and she fell on the road. After that, again Rajshri Bidawat, who was on the wheel, again drove the vehicle over Kaveri Nakhwa and then proceeded towards Bandra Worli ceiling. So this is clearly in black and white mentioned in the remand note which was submitted today at the Savory Court while producing Mihir Shah, seeking his custody, full custody of 7 days.
But why not
As
murder?
Now,
why is the police not
against
Devesh, why is the police not filing straight murder charges under section 103?
Well, Rajdeep, we tried speaking to some of the senior police officials and they are saying that regarding this particular element or regarding this particular revelation, they are seeking further legal opinion whether what sections could be added and whether and if the section of murder could be added. The primary opinion that they have received says that there was no intent of murder, and that is why culpable homicide covers the incident, even though once after toppling Kaveri Nakhwa, dragging her for 2.5 kilometers, and then again after she is released from the vehicle, again running over the vehicle over her body. But despite that, the murder section is yet to be added, and police are seeking legal opinion on that, whether what sections further could be added, whether if section of murder could be added against the accused.
Very strange that the Mumbai Police, known to be one of the better police in the country, does not know what section they are going to file, and why would a murder charge not be filed against someone who has, it appears from the sequence of events, clearly known that there was the woman under the wheel and yet ran over her. This is not an ordinary hit and run accident. Let's get that very straight, which is why we are continuing to track this story to try and put some pressure on the system to actually respond to what really happened. It is our top story because after 3 days since the horrific hit and run that claimed the life of 45-year-old Kaveri, Mihir Shah was arrested yesterday. He is now in police custody until 16 July. He today confessed that he was behind the wheel during the accident, but the hunt is still on for the car's number plate, missing number plate. And while the Shiv Sena today acted to axe his father, who's a member of the ruling Shinde Sena, the question is, A, why did it take so long to find Mihir Shah? And B, why is that murder charge not being applied? Take a look.
More revelations in the Mumbai hit and run case. Sources tell India Today the accused Mihir Shah has admitted that he was driving the BMW when it rammed Pradeep and Kaveri Nakwa's two-wheeler early on Sunday morning. Mihir has revealed that he got scared after he dragged Kaveri on the car bonnet for about 1.5 kilometers. After the incident that killed Kaveri, Mihir went to his girlfriend's house and even tried hiding his identity by shaving his beard to escape the police who were searching for him. After India Today's relentless coverage, Mihir was caught after being on the run for 60 hours. Meanwhile, the Mumbai Municipal Corporation sent a bulldozer to the Juhu bar where Mihir and his friends were partying. The BMC claims illegal structures at the bar were demolished. The crackdown comes a day after the bar was sealed for allegedly serving liquor to underage customers. Maharashtra's ruling party, the Shinde Sena, has sacked Mihir Shah's father, Rajesh Shah, from the party after facing relentless political heat over the case. Uddhav Thackeray's Shiv Sena has accused the ruling party of shielding the accused. Aditya Thackeray visited the victim's family on Wednesday.
This is not just a hit and run. This is not just an accident. This is a murder. Day one, we kept our political decency and we said we will not like to politicize this case. But the fact is, if the accused was allowed to run away and hide for 60 hours, now you start thinking whether there was any politics in this, whether there was any political patronage in this. The bulldozer justice that is meted out to people here and there, on slums, on other people, I would want to see that bulldozer justice happening in this case.
उनको बसाने की कोशिश पहले दिन से चल रही है, क्योंकि बेटे का जो बाप है वो एकनाथ शिंदे वाली शिवसेना का नेता है और बहुत ही रसूखदार आदमी है, पैसे वाला आदमी है, नशे में बार बार कुचल दिया, सड़क पर फेंक कर वापस कुचल दिया. आप देखिए वीडियो, ये तो बहुत ही अमानुष प्रकार है और ऐसी व्यक्ति कभी जेल से छूटनी नहीं चाहिए.
Meanwhile, Chief Minister Shinde has accused the opposition of politicizing the tragic incident.
अपोजिशन हमेशा आरोप करते रहे. उनके पास आरोप के सिवा दूसरा कोई काम है? हम लोग कंस्ट्रक्टिव काम कर रहे हैं, हम प्रैक्टिकल काम कर रहे हैं. हिट एंड रन में जो दोषी है, जो गुनाहगार है, उनको बिल्कुल बख्शा नहीं जाएगा. उनके ऊपर कड़ी कार्रवाई हो जाएगी.
Kaveri Nakwa's family is demanding swift justice. With Dipesh Tripathi and Saurabh Bhaktania in Mumbai, Bureau Report, India Today.
This is not, repeat, not hit and run. This is murder. Mumbai hit and run. More horrific revelations. Why is no murder charge being applied in this case? That is the central question, which is why we made it our top focus. Who is therefore shielding the hit and run accused Mihir Shah? And will justice be delivered? Or is this case going to be buried like many others have in the past? I'm joined today in my political face-off by Susi Ben Shah, she's the Shiv Sena spokesperson, and by Clyde Crasto, the NCP spokesperson. Appreciate both of you joining us. Mrs. Shah, to you first. It appears that the Shinde Sena believes that if we raise an illegal bar, we have done justice to a lady who was mowed over in the most inhuman condition. Bar ko tod do, then Mihir Shah is found after 72 hours. Today you have removed his father from membership of your party, or certainly from his position in the party. Do you believe this is the way to give justice? Why is the police hesitating to apply murder charges in what to me seems to be a clear case of murder?
Rajdeep ji, a very good evening to you and everyone, to all your viewers. Let me tell you this, that bar tod diya to ek shuruaat ki hai. We are proceeding towards a watertight case. Now whether prima facie when the accident happened, the FIR was for culpable homicide not amounting to murder. While the investigation is ongoing, the police is investigating all the aspects of law, all the aspects of investigation. To press a murder charge, we have to prove there was a criminal intent, there was mens rea, there was a guilty mind. Now to prove that, the investigation is ongoing, and we will, when we present the charge sheet, it will be a watertight case whether it be murder, whether it be life imprisonment, or whether it be hanging.
Ma'am, but the police is very clear. They've got the CCTV footage.
Let me complete.
Yes, please go ahead.
Let me complete.
Please do.
Let me complete, sir. Rajdeep ji, when you claim murder, as I said, you have to prove why we are calling it murder. Otherwise, it will not stand before the law, before the bar. Having said that, there is also thing that why not he was 60 hours, alcohol is gone, if at all there was drugs which was gone. Sir, let me if there is alcohol, if there is drug, can you prove guilty mind? A question mark. So let the police investigate. Our Honorable Chief Minister came thrice on the TV on this issue, gave a press conference. Why? To send out a message to the police machinery, to the administration, that this Mahayuti Sarkar is very, very serious. Whosoever you are powerful, justice will be done. The case will be fast-tracked. The highest, the best public prosecutors' services will be employed, and you will see that a charge sheet will be filed, which is watertight and will survive the test of law. Okay. We are not a banana republic. We can't decide on India Today show that whether it's murder, whether it's culpable homicide not amounting to murder. Give us a chance. 60 hours.
Madam, please understand. We are not pronouncing guilt here, but we are only asking what is stopping the police from filing charges under Section 105, which is murder, given the fact that the police itself is admitting the sequence of events in the CCTV footage. It's one thing to run over someone, but then to know, with the knowledge that the person is under your car, you run over her again, and it does not become murder. I mean, that is stretching incredulity.
Rajdeep ji, let them establish beyond a shadow of doubt, just not on CCTV, and we will establish it. Our Mumbai Police, as you rightly said, is one of the finest, only next to the Mossad. Give them an opportunity. Here we are becoming judge, jury, and executioner. ऐसे मत करो भैया.
नहीं, इसमें judge, jury, executioner नहीं है, madam. If the media had not aggressively picked this up, if the opposition had not raised it, the Mihir Shah had run away for 72 hours. No one could find Mihir Shah. Conveniently, he appears 72 hours later. After that, the alcohol has also gone out of his blood.
But alcohol is not the only conclusive evidence. Why are we missing that point? We are thoroughly missing the point, and everyone is harping on the alcohol content. Gentlemen and ladies, let us investigate. Having alcohol in the blood is not the only evidence. There's so many evidences. We have interrogated more than 15 people who have aided and abetted Mihir Shah.
Rajdeep, can I come in?
We have got
1 minute.
CCTV footage. So let us have faith in the system.
Rajdeep, can I come in? Rajdeep, now please, can I come in? Or are you having a monologue here?
The police, the judiciary, everyone is
Let her finish.
Everyone is compromised.
Okay, ma'am. I've heard you now. Clyde Crasto deserves a response. Clyde Crasto, according to the Shiv Sena spokesperson, you cannot turn a TV studio into deciding guilt, and the opposition can't pronounce guilt without first giving the government and the police a chance to prosecute the case.
Rajdeep, I agree that you cannot do anything on a television debate, but the fact where it should be done, why is it not being done? That's the question. Now this Shiv Sena spokesperson keeps saying that the opposition is harping, or the anchors are harping. The fact of the matter is they are harping that there's, what about drugs, alcohol? Man, if you arrest somebody after 3 days, how are you going to find the trace of drug or alcohol in this? And the fact is, alcohol is not just the only evidence. Fair enough, but it's also very important evidence that if the person was driving under the influence of alcohol, more reasons why he should be charged. And why is a section of only 105 applicable, culpable homicide not amounting to murder, when all the evidences, all the CCTV footages, it's already out there saying and showing that they drove over that innocent lady once again. So it is murder. So why should a case of murder not be written on this man? That's the whole question. And the fact is, if you're saying that if it's a watertight case, we will do justice and all everything. If a watertight case was presented, if everything was written correctly, then why was this person's father, Mihir Shah's father, given bail? He was the one who erased evidence. That's what out in the open.
He destroyed evidence. So why was he sent? Why was he given bail? That's the question. Because
one minute, Shah.
when you were talking, I was very decent enough not to talk.
Yeah,
Susi,
go ahead.
I was not talking
Complete
when you were talking. I can also talk in middle. So let's have some decency. The point, so Rajdeep, the point here is, if there was a watertight case, then why was this man's father given bail? He was there destroying evidence. Also, the other section, like you said, why was section 103 not applicable? Now, what I'm trying to say is, hear me out clearly, Rajdeep. We have the writ of mandamus. There's something called writ of mandamus. Is the state government going to go for a writ of mandamus and go and seek justice from the court, saying that go for the writ of mandamus? Whoever is involved in this investigation, all the investigative authorities, bring them under the ambit of the writ of mandamus, expedite that case, and make sure that these people get justice, and this criminal, this culprit, Mihir Shah, who ran over this innocent lady, is brought to book and severe punishment is meted out to him.
Okay,
Justice
1 minute.
has
Clyde
to be
Castro,
given to this lady.
just
come
a minute.
On, have a heart, yeah?
No,
Rajdeep,
it's
one
not a
second,
question of a
one
heart.
minute.
You
One
see,
minute.
One minute, Clyde
Let me
Castro,
finish.
there is no, you know, the
Let me
problem
finish.
is...
You are not allowing me to finish.
No, sir,
No,
you've
no.
been
But
speaking
you can't
continuously
go-
for the last 2 minutes. You are not answering one central question. It is now 1 minute, sir.
But you're not allowing me to...
No, you must wait.
But I'm answering all the questions.
Three days have gone.
What is your question? Ask me, I'll answer it right
Yeah,
now.
please. 72 hours have gone since this hit and run case took place, which now is being seen as murder. Mihir Shah has been arrested. Members of his family have been arrested. The police is assuring, and so is Ms. Shah on this program, that if necessary, more charges will be put in place. The police is fully investigating it. Even the bar in which he was drinking before this happened, part of it has been demolished. And the father has been sacked from his post. What more do you want at this stage? At this stage, this is a preliminary stage, 72 hours only have gone. Mr. Castro.
So now can I answer?
Yes.
That's what we are trying to, that's what I'm answering. That's what I'm trying to say. The point here is, if a watertight case was there, why was the father given bail? I'm asking you the same thing. Was the same assurance not given in the Pune Porsche case? What happened? Blood samples were changed. A 2-member judicial board should have given the judgment. One person was sitting and giving the bail to the accused. So these things have happened before. We've seen it happen before. All we are saying is that this should be a watertight case, and what we are doing is, as an opposition, you as a media person, we are raising the right questions. What we are not doing wrong here.
Okay, I've heard you now.
That's the question.
I've heard you, Clyde, very patiently.
That's what I'm trying to say.
I've heard you patiently. Ms. Shah, public opinion is very clear. It seems that the public wants swift and sure justice.
Yes.
The fear is that because this is an influential papa's son, and because this influential papa is close to your chief minister and is your leader, therefore the leader at some stage or the other will try and protect him. Once the media dust settles down, he will be protected, is the fear. And there is an election in Maharashtra in 3 months. That's why you all are now under pressure, acting. Would you concede that to some extent at least you could have shown this swiftness on day one itself, when Mihir Shah suddenly escaped and the father also got bail within 24 hours?
Mr. Sardesai, let the facts be known. Today I was with the family, and earlier I was with the family on another TV debate. And the family very clearly said that they were very, very happy with the swift action taken by the police. That's number one. Number two, as far as the bail given to the father was concerned, it was not given by Shiv Sena. It was given by the justice, the wisdom of the judiciary. In fact, the judge opined that when the father was not even with the son, how can you levy such strict charges?
Because
So
the
therefore,
father,
the
because the
opposition-
father may well have been involved in destruction of evidence. That's why.
He was in the police station within an hour of the incident happening. This is the only case so far, because the message went straight from Eknath Shinde that act swiftly and surely, that he was in the police station without his phone. Number one. Number two, now there are two things that they're talking about murder. That also is the main topic of this show. Now, whether to establish murder, do you think we have to examine, we have to investigate whether to prove that the man was under alcohol? Will it help the murder charges? Subject matter to investigation. Let us investigate. Let us investigate thoroughly.
No, because the fear, Ms. Sushiben Shah, is the Mumbai Police today is under intense political pressure, not just in this case. We've seen in recent cases, the police, which you said once had a great reputation, is now the same police, irrespective of who's in power, which seems to take action based on political pressure. That's the reality. We've seen that happen at the senior most level in the Mumbai Police in recent times, right up to the level of commissioner.
In this particular case, there was no political pressure. Now, yes, you are right. The arrest could have been a little earlier than 60 hours, for which the police will have to reply. But, sir, 3.6 crore people, Mr. Sardesai, in the MMR region. He had switched off the phone, no electronic footprints. The minute the Mihir Shah started the phone, he was arrested. 12 teams running across Mumbai and MMR region, tracking the movement of Mihir Shah. So we have taken, the Mumbai Police, the administration have taken it seriously. My humble appeal is only give us time to file a charge sheet which does not fail.
Okay, we are going to, ma'am, we will give you time, but we are going to monitor this case very closely. As I said, there are elections in Maharashtra 3 months, and maybe therefore the government also will be under political pressure to act. There will be media pressure, and we will continue to look at every twist and turn in this case, because this is a test case now. That the manner in which the woman Kaveri was killed is beyond shocking.
Yes.
It is absolutely a shame that this should have happened in a city like Mumbai. We talk of the spirit of Mumbai, and when something like this happens, Mumbaikar should get far more angry than they are, and we will therefore continue to reflect that anger which should be there on the street against such instances. Today it was Kaveri, tomorrow it can be someone else. Too many people, ma'am, have got away in this country with hit and run case.
We will not fail you.
Okay, I will take your assurance. Clive Castro, you want a final quick word? Are you willing to give them time? They want time.
Well,
investigation.
no, the question is, it's not them. It's not them who have to do with the justice. 1 minute, Sushiben, he's asked me a question. The justice has to be given to the victims. And one thing that has to be made sure, there is no political pressure on the police. The Mumbai Police is far better than what Sushiben Shah is saying, that, there was no digital footprint and they didn't know what has happened. They are far better than this. They can trace anybody, even if they do not have a digital footprint. You know that, Rajdeep, and I know it. But the fact of the matter is, in the Pune Porsche case and the Mumbai case, we know there could be political pressure, and the government has to assure that there is no political pressure on this, and they have to set an example.
That's the assurance they have given. We will
all these brats,
they will have to walk the talk.
Think twice before they drive their cars.
Time out.
Louder than words.
Time out. News without the noise. We've heard both sides. And the people of Mumbai and the country will watch and see whether this becomes a test case, whether justice will be done in a case like this. Kaveri's family deserves swift justice. Let's turn from there, speaking of justice, to another case. That's our headline today. A landmark alimony judgment by the Supreme Court today. In a big relief that could extend for all Muslim women, India's top court today ruled that all married women, including Muslims, are entitled to maintenance from their husband after divorce under Section 125 of the Code of Criminal Procedure. What does this mean? Kanu Sharda has more details.
The Supreme Court today ruled that a divorced Muslim woman can seek alimony from her husband under Section 125 of the Code of Criminal Procedure. The judgment came as a bench of Justices B.V. Nagaratna and Justice Augustine George Massey dismissed a Muslim's man petition challenging a direction to pay his wife maintenance after divorce. The court today made it clear that the law for seeking maintenance applies to all married women irrespective of their religion, and has held that the maintenance is not a matter of charity but a fundamental right of married women. The top court also said that some husbands are not conscious of the fact that the wife, who is a homemaker, is dependent on them emotionally and as well as in other ways. Time has come for Indian men to recognize the indispensable role and sacrifices made by housewives for the family. With camera person Nasir from New Delhi, this is Kanu Sarda for India Today.
What does this judgment mean? How will it change the lives of Muslim women in particular? We want an explainer to be done. As I said, we are slowly trying to move away from every debate becoming a shrill face-off. This is what we call our explainer section. Joining us now is Shadaan Farasat, advocate at the Supreme Court, and I'm joined by Zakia Soman. Zakia Soman is the activist who campaigned against triple talaq. I appreciate both of you joining us. Shadaan, give us your sense. What does this judgment mean? Does it mean upholding the primacy of, dare I say, secular laws over anything that is seen to be reflected to Sharia or a community-centric law? You're on mute.
Fundamental.
Yeah, go ahead.
It actually reiterates. Yeah. Clearly?
Yeah, now I can.
So it fundamentally reiterates the existing position of law, which is that under 125 CRPC, Muslim women, even subsequent to divorce, have a right. So that position of law has existed under various judgments already. It reiterates that position to some extent. There is a certain aspect of interpretation on the 86 Act, which it says that those two.
Okay, we'll try and get our
They do
lines.
not override.
We're having a problem with your line, Shada. We'll try and get that fixed in a moment. Meanwhile, Zakia Soman is joining us. Zakia Soman, do you see this as, again, the Supreme Court, as Shadaan said, reiterating that the Supreme Court believes laws on issues of maintenance, on issues concerning the personal rights of women must be uniform and they must be gender neutral and above any form of religious law?
Yeah, but I would like to frame it a bit differently, because the judgment here is reiterating the constitutional promise of gender justice and gender equality. Mention of maintenance to be given to a divorced wife in the Quran. It is the violation of this provision which has resulted in this situation. And also the resistance to reform in Muslim personal law, resistance to codified Muslim family laws, which has led to this kind of an impasse. And now I think we have come a considerable distance from Shah Bano in 1985 to Justice Nagaratna and Justice Masih now giving this judgment. And they're saying that maintenance is like a fundamental right. It's not a charity. And, there needs to be, we need to have this change in our mindset. The mindset of the patriarchal mindset, in a marriage when things go awry. The husbands, some of the husbands tend to think that they want to look for loopholes to escape the responsibility of providing maintenance to your wife.
Right.
So this provision already exists in the Quran. It's unfortunate that it could not translate into personal law because we do not have a codified personal laws. And I am so glad that this judgment is addressing a long-pending need of the Muslim women, and it is enabling Muslim women to attain legal parity with other women, be it Christian women, be it Hindu women, in terms of maintenance after divorce.
Right.
So it's a very, very welcome and a progressive judgment.
The reason I'm asking you this, and Shadab, maybe we can look at chronology. You had the Muslim Women Protection of Rights on Divorce Act 1986 in the backdrop of Shah Bano. It became a huge issue where the Rajiv Gandhi government was accused of succumbing to extremist fundamentalist voices. Then you had in 2019 Muslim Women Protection of Rights on Marriage Act 2019, where any pronouncement of instant talaq was declared void ab initio and illegal. And there was up to 3 years in jail and fine for instant talaq. So from 86, where the state was seen to have succumbed, many believe, to extreme voices that were refusing to accept a codified personal law, to what happened in 2019 to now today, is this all progress towards gender-friendly, gender-neutral laws?
Oh, yes, the simple answer is yes, but I think it's more than that. See, you are right that the 86 Act was to undo the Shah Bano judgment under the Rajiv government then. But even the Supreme Court then, in its interpretation in Daniel Latifi and in other cases, had actually given broadly the same meaning which the Supreme Court has in fact reiterated today. But I think the real meaning of today's judgment is this. I think there is a whole part in this judgment in about how there has to be equal sharing of financial resources even in a normal subsisting marriage.
Right.
For instance, it should not be in India, the workforce participation of women is only 37%. So that is 37 out of 100 women capable of participating are participating, right? So you still have more than 60% of women as homemakers. And for them, financial independence means that there has to be a mechanism to share the resources, even in a subsisting marriage, not just in a marriage which has gone awry and there's a divorce and there's a question of maintenance. For instance, joint accounts. There's a discussion on how they should be joint accounts and the wife should have continuous access to financial resources in consonance with her dignity. She's not dependent. It's important that a man realizes that if he's the one who's providing the finances and the wife is taking care of the home, then the finances are available to wife in a dignified manner. I think these kind of discussions which are there in this judgment are new in the sense that they are very nuanced. They understand a functioning of a family in the Indian context very well. And it's therefore to that extent a completely new addition.
So does it stretch? So you're saying it stretches across the community divide. It is making it's making a principled point that a woman is entitled to maintenance, whether Hindu, Muslim, doesn't matter.
Yeah.
They're looking at it, therefore, isn't it therefore a step towards what I said, gender neutral laws?
Gender neutral, and the concept of family and the responsibility in a family of both the husband and the wife, especially when the wife is not earning. And this is even in a functioning marriage, right? So it is really to that extent very progressive, but it goes beyond the classical judgments, which are in the context of divorce. I think the judge, the concerned judge, has really made an effort to actually realize the day-to-day realities of an Indian marriage and how it works on the ground and try to address that head-on. And I think from that perspective, it's very, very progressive and it's very welcome.
Zakia Soman, as I said, the chronology suggests that the law is moving with the times in a way to ensure that family rights, protection for the woman are given a certain primacy, which perhaps in a more patriarchal system they were not earlier. This is trying to break away from those patriarchal stereotypes and recognize the woman's rights.
Yeah, definitely. And there is a lot of awakening and consciousness within the communities also. Not only the women who are much more aware about sections of the community also recognize that women should be given their rights, granted by the
We are again having some problem, ma'am, with your audio. We'll try and fix that. But I'm going to, in conclusion, ask you, Shadan, how does all of this, it's very interesting that I haven't heard any opposition even from the usual suspects, whether the All India Muslim Personal Law Board or those clerics who in the past have sort of questioned the manner of whether courts can intervene in this space. It seems that there is a willingness to accept, therefore, that women married under Special Marriage Act will get these benefits. And if a woman has been divorced in a valid way, she can move either under the previous act or she can move under Section 125, and they've accepted it.
Yeah, so not a Special Marriage Act. This was a case of a normal nikah, which is under personal law itself.
Right.
So even under normal, you are right. I mean, so if from 1986 there was mass protest over the Shah Bano judgment. Today we are not seeing any of that, and that's welcome, and that's the way it should be. Everybody should learn to see the things as that should be, and I think it's quite good that there's acceptance. In fact, I would go so far as to say that not just there should not be any opposition, but even things like AIMPLB should actually, frankly, welcome a decision like this. It will also improve their position in the society of what kind of organizations they want to be seen at, as not just somebody who is in that sense trying to stop change, but also welcoming change when it's actually in the interest of equality, it's in the interest of gender justice.
Okay. I think we've heard perspectives that reflect the fact that this is an important step forward again in gender justice. Yes, Zakia, you're back with us. You want a quick minute on that? Do you feel that with every such judgment, women feel more and more strengthened?
Definitely. And also the community is changing. The women are changing. The community is changing. And there is no more that kind of sole reliance on the conservatives. The conservatives are getting somewhat irrelevant. I might make bold to say that. and there are enough number of sane voices within the community who understand the nuances involved in this kind of a situation. And there is overall a consciousness and a demand for change. And these judgments are going to encourage that kind of those kind of developments.
Let's leave it there. We've heard two voices to try and explain this judgment that effectively means that women, all women, have that right to alimony, including those who've had a nikah under Muslim laws. They too will be entitled to these benefits. Shadan Farasad and Sakya Soman for explaining that judgment and its importance to us. Thank you so much. Let me turn from there to the Enforcement Directorate. Elections are over, but the ED has found Karnataka, the latest opposition state, to find itself under the ED's crosshairs. The ED has intensified its probe into the alleged Valmiki Corporation scam in Congress-ruled Karnataka, conducting simultaneous raids at multiple locations today. Former Karnataka Minister B. Nagendra and Congress MLA Basangauda Dadal are under scrutiny following revelations of an alleged illegal transfer of 187 crores from the corporation. Interestingly, in Shiv Sena BJP-ruled Maharashtra, in another corruption case involving a ruling party MP, Rajendra Vaikar, the Mumbai Police has gone ahead and closed the case, and the central agencies are expected to do the same. It raises the question, is the ED playing washing machine politics once again? Take a look.
The Enforcement Directorate launched simultaneous raids at multiple locations, including premises linked to former Karnataka Minister B. Nagendra and Congress MLA Basannagowda Daddal. The raids are part of an investigation into the Valmiki Corporation scam. The ED is probing the alleged illegal transfer of 187 crore rupees from the Karnataka Maharshi Valmiki Scheduled Tribes Development Corporation. Congress MLA Basannagowda Daddal is the chairperson of the Valmiki Corporation. The scandal came to light tragically with the suicide of Chandrasekharan P., the corporation's accounts superintendent. In his suicide note, Chandrasekharan mentioned some officials and the word minister. Nagendra had resigned as the Minister for Tribal Welfare and Youth Empowerment after uproar over the suicide. The ED raid comes a day after Nagendra and Daddal were questioned by the Special Investigation Team formed by the Siddaramaiah government to probe the scam. The opposition BJP has hit out at the Congress government.
State government is trying to protect its MLAs and ex-ministers. So it's quite natural when the FIR is registered based on the letter given by the Union Bank of India. When CBI has registered an FIR, it's quite natural that, ED has entered the fray.
The Congress claimed the culprits will not be spared.
The investigation is going on. We are very transparent. We don't want to involve in the investigation. Our Honorable Minister has resigned to give a way for a free and fair investigation. I think there is nothing wrong. The investigation will come out as early as possible.
In addition to the ED, the CBI is also investigating the case. The crackdown by central agencies in Karnataka are in contrast to another corruption probe in neighbouring Maharashtra. The Mumbai Police Economic Offences Wing has closed the case against ruling Shiv Sena MP Ravindra Vaikar in an alleged 500 crore rupees hotel scam exposed by BJP leader Kirit Somaiya. Vaikar had switched from Shiv Sena UBT to Chief Minister Eknath Shinde's Shiv Sena ahead of Lok Sabha elections. He was elected MP from Mumbai Northwest Lok Sabha seat. The opposition is questioning the clean chit to Vaikar.
ये वाइकर है, आयकर की सभी कार्रवाइयाँ स्थगित होगी क्योंकि अब मोदी जी के और गुजरात के वॉशिंग मशीन में वो चले गए हैं.
जो उन्होंने उस दिन भी साफ सुथरा बता दिया कि सुप्रीम कोर्ट ने उनको रिहा कर दिया था, तभी की जो बात है. और हमारे पास आया, हम लोगों ने उनका सम्मान किया, उनको टिकट भी दे दिया और उनको चुन के भी ला दिया. तो पब्लिक ने स्वीकारा है. ऐसा नहीं क्या 2, 5, 10 हजार वोट से निकल के आया है. ये तो 17, 18, 19 लाख वोट में से चुन के आते हैं. तो इतने पब्लिक ने जो को उनको वोट मिला वो ऐसा ही मिला कि अगर उनके ऊपर जो कोई होता था क्लेम तो चुन के नहीं आ जाता था.
with Sagai Raj, Anaga Keshav in Bengaluru and Divyesh Singh and Sahil Joshi in Mumbai. Bureau Report, India Today.
Let's turn now to our Get Real India story, which tonight comes from Uttar Pradesh's Unnao, where tragically 18 people, 1-8, lost their lives, several sustained injuries after a horrific passenger bus collision from Bihar rammed into a milk tanker on the Agra-Lucknow Expressway. This story once again puts the focus on the increasing number of road mishaps across the highways of the country. Take a look.
Dead bodies scattered on the ground. Twisted scrap of metal and shattered glass. These heart-wrenching images are from Unnao. A passenger bus travelling at a high speed on the Lucknow-Agra Expressway rammed a milk tanker. Most passengers were asleep when the accident took place early Wednesday morning.
सुबह में सो रहे थे तो मुझे झटका लगा तो नींद टूटी तो सारे आदमी चिल्ला रहे थे तो मैंने अपने लड़का को कहा कि नीचे उतरो नीचे उतरो। जब वो नीचे उतरा तो मैं छोटा वाला लड़का को नीचे उतारी। मैंने ऊपर से उतार के देखी तो सारे आदमी कहीं है पर लटक रहा है।
सब लोग डेड बॉडीज था वहाँ?
जी, यहाँ पे सारे कहीं, वहाँ पे एक सोया लटका था, यहाँ पर किसी का सर नीचे था।
Many of the travellers on the bus were migrant workers going from Bihar to Delhi. Initial probe suggests that the bus was over-speeding.
घायलों का उपचार जिला अस्पताल में चल रहा है। 5 घायलों को रेफर किया जा रहा है लखनऊ बेहतर उपचार के लिए और सभी बचाव कार्य किए जा रहे हैं और जो मृतक और घायल है उनकी पहचान सुनिश्चित की जा रही है। उनके परिजनों को सूचित किया जा रहा है। नंबर भी जारी कर दिए गए हैं जिस पर वो फोन करके सूचना प्राप्त कर सकते हैं।
UP Chief Minister Yogi Adityanath paid condolences to bereaved families. Prime Minister announced ex gratia of 2 lakh rupees to the next of the kin of the deceased. The Unnao mishap has put the focus on road accidents in India. 1,68,491 people lost their lives in road accidents in 2022, according to the government data. That means over 460 deaths a day, 19 deaths every hour. Bureau Report, India Today.